When property owners neglect their homes, a city tries to have the homes demolished in Bonner v. City of Brighton. Leon and Marilyn Bonner owned 2 properties in Brighton. No one lived in the houses, and the Bonners had neglected the properties for 3 decades. A Brighton official sent the Bonners a letter notifying them that the buildings weren't safe under the Brighton Code of Ordinances and were nuisances under state law. In support, the official noted many code violations. The official determined that it wasn't reasonable to repair the buildings under the code because the cost to repair would be greater than the property's value as assessed by Brighton. In those situations, the code permitted Brighton to require demolition without giving the owner an opportunity to repair. Brighton ordered the Bonners to demolish the buildings, so the Bonners appealed to Brighton City Council. For the appeal, the Bonners hired contractors and engineers to determine whether the buildings were safe and could be brought up to code. The City Council upheld the findings in the official's letter and ordered the Bonners to demolish the buildings. The Bonners filed suit against Brighton for various claims, including violation of the Bonners' substantive due process rights. Brighton filed a separate lawsuit, asking the court to require the demolition. The court combined the cases. The Bonners moved for summary judgment, arguing that the ordinance requiring demolition wasn't constitutional. The court found it violated the Bonners' substantive due process rights because it didn't give the owners the chance to fix their properties, which didn't serve a rational purpose. Brighton appealed.